Hi, I'm Arno Lodder from the University Amsterdam, Department of Transnational Legal Studies. And the point I want to make today is that public international lawyers should focus more on the characteristics of the internet. And the title of my presentation is There's More to Cyberwar Than Death and Destruction. And because this is a privacy conference, I'll also say a little bit about privacy. And I start with the date of today. It's January 25th. And a year ago, as my colleague Vendenhoven van Genderen labeled it, it was Privacy D-Day, a real invasion of privacy. The proposals by the European Union of a privacy resolution and a directive. I'm sure it will be discussed at length during this conference. And so that's the first connection between war and privacy, Privacy D-Day. And if you have a question about things today, you go to the modern oracle, Google. So I Googled and I found some titles about privacy and cyberwar. And they all basically come down to that if you want to do something serious with cyberwar, you have to do something about identity on the internet, and in particular anonymity on the internet. And of course, that touches the issue of privacy. What I want to focus on is that if you have a new phenomenon, and that's what internet lawyers do all the time, there's a change in society, and you have to think about, does the existing law still fit? And there are basically three steps you take. First, you see whether existing norms as such apply. An example is contracting. If you contract over the internet, there's nothing different from normal contracting. It's just offer an acceptance or meeting of the minds. And the second step is, if the norms as such do not apply, do existing norms apply after making them fit? And a nice example is from the Supreme Court of the Netherlands last year, January. They ruled on virtual theft. So theft is a classic criminal act, and the Supreme Court made some interpretations, some analogies, and concluded that it's possible to steal a virtual object, a virtual mask, and a virtual amulet. And then if even interpretation or analogy doesn't work, you have to think about, do we need new norms? And a good example is cookie regulation. There's not really analogy in existing law to cookies, so that's why new regulation was drafted. It's also a good example that you also have to think about, is it really necessary to draft new norms? And there, cookie is of course also a very good example. And what I want to do is to illustrate that public international law is focused too much, in my perspective, on applying existing norms and a bit on making them fit, but too few on the third category. And I want to do that by going through some rules of the Tele Manual. It's a war manual for cyber warfare, published at Cambridge University Press 2013. It's a very good piece of work, but I think it could have been somewhat better. And I go through some rules to make my point clear. I start with Rule 11. It's about the definition of the use of force. And it makes a connection between the level of use of force in normal circumstances and on the internet. But you can't really compare those two. They're so different. And then again, if you really apply the use of force to cyberspace, then the question is, you might be legitimized to react as a state, but against who? Should you go to Russia or Iran? You basically don't know who's on the other end of the attack or the threat. So although you might be able to apply existing legal norms, the consequences aren't clear. It isn't clear how you can come to practical consequences of the application of the rule. Then another example is Rule 30 about the definition of a cyber attack. And it's again about death to persons or damage or destruction to objects, but it's not what the internet is about. The internet is about data, and data are not physical, so the consequences can be very different. You have to think about it in a different frame of mind and not touch too much upon the physical characteristics of the objects and persons. Then there's another rule, Rule 33, about the doubt as to status of persons. If you're not sure if someone is a civilian, you should treat him as a civilian. But if you don't know anything about who's on the other side of the line, the internet line, then all people are civilians. So that's also a bit tricky rule to apply to the internet. And as a bit follow-up, Rule 34 is about persons as lawful objects of attack, members of armed forces, members of organized armed groups. But persons, the internet isn't about persons. The internet is a network of computers. And there are people behind these computers, of course, but the internet is not a network of identifiable persons. And then, to me, one of the nicest examples, the improper use of enemy indicators. It's prohibited to make use of flags, military emblems, insignia, uniforms. But in cyberspace, a flag, you got mail, maybe. Or would there be a Russian cyber warrior with an Afghan flag or whatever? It's so strange to think about these physical things in a cyberspace context. A uniform. Would the American cyber warrior be dressed in a Canadian uniform? Of course not. Emblem the same. So this is an example of a rule that's tried to make fit to cyberspace but doesn't take into account the characteristics of cyberspace. And then finally, especially for this conference, Rule 75 about protection of detained persons. So if you're imprisoned, then your personal data will be protected and the detention regime will respect privacy. So that's good to know that you're not only a number as a war prisoner. So, in sum, what it boils down to is that the point I want to make is that if we look at cyber war, we should focus on cyber war and not on cyber war. Because cyber war is about threats and attacks in cyberspace. You should take into account the characteristics of the internet, the characteristics of cyber, like anonymity, scalability, borderlessness. And then there's another point. If there's a threat or if there's an attack, it can be military, it can be civil, it can be criminal. There's this attribution problem. You often do not know who's threatening you or who's attacking you. So this is a real challenge. We might leave the existing normative framework and try to think about another approach to those attacks and threats. Not in the traditional pillars of internal affairs, secret services, military services, but just as a general governmental organization that tries to handle those threats on cyber. So that's the point I want to make. Thank you for your attention.